British MP Debbie Abraham, who is also the chair of all-party parliamentary group for Kashmir, was denied an entry into India as her e-visa had been rejected by India. What is the issue? India has denied entry to a UK Labour MP who was critical of the government controversial decision to revoke Kashmir special status last year. Indian officials have clarified that the British lawmaker Debbie Abraham, who was denied entry into the country on Monday, did not hold a valid visa. This was done after various media organizations claimed that Abraham was deported. The Ministry of External Affairs also responded that on account of her involvement in activities against India's national interest, her visa had been revoked. In this case, the government had claimed that this instance of denial of entry is not same as deportation as a British MP has claimed. Now I will tell you what does rejection of visa mean. Grant, revocation or rejection of a visa is sovereign right of a country. Any foreign national who remains in any area in India for a period exceeding the period for which the visa was issued to him can be proceeded against under Section 14 of the Foreign Act 1946. A foreigner who enters into or stays in any area in India without the valid document required for such entry or for such a stay, as the case may be, can also be proceeded against under Section 14A(b) of the Foreigner Act 1946. What is deportation? Deportation is the expulsion of a person or group of people from a place or country. It can be done by a country when a foreigner violates the immigration laws of the country. It applies equally to nationals and foreigners. Types of deportation. First, external deportation. All countries reserve the right to deport persons without right of award, even those who are long-time residents or possesses permanent residency. In general, foreigners who have committed serious crimes, entered the country illegally, overstayed or broken the conditions of their visas, or otherwise lost their legal status or to remain in the country may be administratively removed or deported. In some cases, even citizens can be deported. Some of the countries in the Persian Gulf have deported their own citizens. They have paid the Comoros Islands to give them passport and accept them. Second, internal deportation. Deportation can also happen within a state when an individual or a group of people is forcibly resettled to a different part of country. If ethnic groups are affected by this, it may also be referred to as a population transfer. The rationale is often that these groups might assist the enemy in war or insurrection. For example, the American state of Georgia deported 400 female mill workers during the Civil War on the suspicion they were Northern sympathizers. Third, colonial deportation. Deporting individual to an overseas colony is a special case that is neither completely internal or external. For example, from 1717, Britain deported around 40,000 religious objectors and criminals to America before the practice ceased in 1776. Jailers sold the criminal to the shipping contractor, who then sold them to plantation owner. The criminals were forced to work for the plantation owner for the duration of their sentence. After Britain lost control of America, Australia became the destination for criminals deported to British colonies. Fourth, criminal deportation. Criminal deportation is where a foreigner is ordered to be deported or physically removed from a country by reason of such a person's criminal conduct or activity. Now I will tell you what are the regulations applicable to the foreigners in India. First, the Passport Act 1920. It prescribes specific authorization of foreign nationals on their valid travel documents for allowing entry into the country. Under this act, foreigners coming to India are required to get a visa from Indian missions or post. Second, the Foreigners Act 1946. It regulates the entry of foreigners into India, their presence and their departure. And now third, the Registration of Foreigners Act 1939 and the Registration of Foreigners Rules 1992. It mandates that certain categories of foreigners whose intended stay in India for more than the specific time or as provided in their visa authorization are required to get themselves registered with the registration officer. Power to grant or refuse permission to enter India under Foreign Act 1946. Permission to enter shall be refused if the concerned authority is satisfied. That means the foreigner is not in possession of valid passport or visa for India or has not been exempt from the possession of passport or visa. He is a person of unsound mind or a mentally defective person, and he is suffering from an infection, diseases in consequences of disease in the opinion of the medical officer of the port. The entry of the foreigner is likely to prejudice public health. He has been sentenced in a foreign country for an extradition offence within the meaning of Indian Extradition Act 1903, 15 of 1903, and his entry is prohibited either under an order issued by a competent authority or under the specific order of the central government. The civil authority may attach such condition as it thinks fit to grant or refuse permission to enter, which includes the interest of public safety.